Good morning, London! You're watching London's favorite morning news by our authority. Update on Mars 1, a program anyone can apply to be sent to Mars for permanent human settlement. No one has applied. However, there has been unanimous support from the international community to sponsor Kim Jong-un. And in our southern neighbor, California has brought Hartford Fire Insurance Company to court, claiming that the company, in tandem with other London, England-based reinsurers, has conspired anti-competitive activities. This is a controversial U.S. Supreme Court case. One of the main issues is whether foreign companies acting in foreign countries could be held liable for violations of the Sherman Antitrust Act in America if they conspired to restrain competition within the U.S. Joining us this morning is the attorney representing Hartford Insurance Company, Stephen Shapiro. Mr. Shapiro, thank you for joining us. Please, we appreciate your insight.
Oh, yes, hello, and thank you for having me on the program. I think it's a pretty good idea to send Kim Jong-un off to the Red Planet, and I'm honored to have him represent our human race millions of miles away from us. You see, Hartford Insurance vs. California has two very crucial points. My clients were accused of participating in the forms development process and were accused of violating the Sherman Antitrust Act.
The bottom line is whether or not your clients conspired with foreign companies that were not subject to state regulation, thus violating the Sherman Act. In layman terms, your clients conspired to organize a boycott.
The Sherman Act prohibits business activity that the federal government deems as anti-competitive, requiring federal government to investigate trusts. Our stance is that Hartford is not in violation of the Sherman Act due to their entitlement to the McCarran-Ferguson Act.
And what is that?
The McCarran Act permits insurance companies to agree amongst themselves on acceptable terms, conditions, and coverages. Thus, my clients' mutual terms with the foreign reinsurers can't be deemed a boycott.
And you're saying that that's precisely what your clients did? They acted within the confines of the McCarran Act?
Yes.
Your clients are being considered under 1, forms development, and 2, market conduct. With forms development, your clients and the foreign defendants agreed that they would not do business with reinsurance companies unless changes were made in certain advisory insurance forms. Your clients gave other companies an ultimatum. That very much looks like exclusive activity to benefit themselves. How is that not a boycott?
Because, as I said before, the McCarran Act permits insurance companies to deal with one another within the industry. My clients simply agreed on mutual terms of coverage.
Whoa, Mr. Shapiro. I can understand why an insurance company has an interest in getting the reinsurer to agree that he will insure this kind of insurance, this kind of a form. I don't understand why it's important to your clients to know that the reinsurer will not insure another kind of risk or will not accept another kind of form. Why is that necessary?
Because of the solvency rationale. The solvency of the reinsurer is vitally important to the reinsurer. If the reinsurer becomes insolvent, the insurer is left with the burden. If the reinsurer is engaging in risky coverage, that is a risk to the primary insurer as well.
Let me just make a distinction for our viewers here. Insurance companies buy insurance for risk management from reinsurance companies. It still sounds a lot like a boycott to me, Mr. Shapiro.
It wasn't a boycott because this was the standardized agreement that applied to everybody the same way. All associating parties negotiated at length and came to the conclusions together. It is not discriminatory.
What about the consumers?
Well, when Congress passed the McCarran Act, Congress recognized the industry as unique.
What industry?
The insurance industry, and agreements made within it promote insurer solvency and consumer welfare, even though they have anti-competitive effects.
Okay, sure. But I want to go back to the business deal ultimatum. At this meeting, your client and another insurer, General Rate, agreed to coerce reinsurers to adopt their demands. If reinsurers fail to do so, your clients and your clients' colluding companies would derail the entire forms process.
It was not coercion, as it was simply that the insurers and the reinsurers agreed that certain coverages are unacceptable to them.
But this impacts third parties.
Well, any agreement would have an impact on third parties, but that is...
I don't mean by the people who buy insurance. I mean competitors. They've been singled out, as you would say.
Take St. Paul Insurance vs. Barry. By singling out a group of doctors and treating them differently from everybody else in the market, they were able to penalize them and completely cut off their insurance. There's a stark contrast between that case and what's going on here. That's because Hartford applies to everybody in the exact same way. This is a critical distinction in the Barry case, and yet you continue to override that distinction.
But still, your forms development has anti-competitive implications.
Irrespective of the anti-competitive implications, Hartford did not conspire with somebody outside of the industry. As seen in the group life and health insurance company versus Royal Drug Company, It is only when somebody conspires outside the insurance industry that they're not entitled to the McCarran Act.
I want to remind you, Mr. Shapiro, that the Pyreno case, which established the royal drug consideration, indicates that conspiring with somebody outside of the industry is a factor for consideration.
Just a single factor.
Yes, but it is a factor nonetheless. Okay, moving on to the second type of conduct considered in this case, market conduct. Your client's activities have been brought to court because the foreign defendants jointly decided that certain coverages would not be reinsured. There's a valid concern here that this is anti-competitive.
That's the claim, yes, and even though they have anti-competitive effects, Congress left it to state insurance regulators to decide which agreements were permitted and which were prohibited. Under the McCarran Act, it is a contradiction to talk about boycott of unacceptable terms, coverages, or forms the same way plaintiffs do through these complaints.
Thank you for your time, Mr. Shapiro.
Thank you for having me.
And there you have it. Plaintiff California brought this case up because they felt the activities we've talked about today between Hartford and other insurance companies against London-based reinsurers produced substantial effects on the market for insurance in the U.S. Jurisdiction was established for the case because no conflict existed between the American Sherman Act and British law. The reinsurers claimed comity, but U.S. courts denied it for lack of conflict. Mr. Shapiro's statement, as you heard it today, cites the McCarran-Ferguson Act, claiming immunity from the Sherman Act because of intra-industry agreement. The courts ruled that the actions of the defendants did constitute boycott. I'm Cindy Zhang, and you're watching London News.